At a Senate Judiciary confirmation hearing, Senator Chris Coons of Delaware pressed Jennifer Mascott, nominated to serve on the Third Circuit Court of Appeals, on her views regarding presidential power. The questioning centered on whether President Trump had the constitutional authority to withhold funds that had been lawfully appropriated by Congress.
My core concern is that our framers drafted a constitution in order to constrain powers, the separation of powers, which you've taught. They put Congress as the Article I branch, not the president, because they were principally concerned about constraining an overreaching executive. In a brief that you filed challenging President Biden's effort to cancel student debt, you wrote, "The power of the purse is one of Congress's most potent checks on the executive branch." I asked you yesterday if you'd ever advised the White House on impoundment issues, whether President Trump could refuse to spend money Congress has appropriated. You said that you had. Did you advise the White House President Trump can refuse to spend money legally appropriated by this body?
So Senator, I appreciate your question reference to Article I and appropriation. I know we talked about that a bit yesterday, and also, having clerked for Judge Kavanaugh, he, as a former executive branch lawyer, also pointed out the president's role in having to sign off or veto legislation. The particular question you talked about, I believe, I recall in our discussion that I had mentioned that I had not been working on that issue recently, that I was asked a discrete question actually prior to the start of the administration on the constitutional question that are related to that topic. But beyond that, really sitting here today as a judicial nominee with some of these issues playing out in the courts as we speak, I cannot further comment on the question.
You publicly stated in March of this year that the Supreme Court's 90-year-old Humphreys executor case was wrongly decided. Do you stand by that statement?
So, Senator, as an academic, and I've taught in other forums, I strongly stand by my past work. Sitting here as a judicial nominee, what I also mentioned yesterday a number of times was my commitment as a lower court judge to a fully and completely applying Supreme Court precedent, and also the case that you mentioned, Humphrey's executor, in the Supreme Court's own writings that has referred to it in the past decade, 10 or 15 years, as a narrow exception to the broader principle that the president, vested with the executive power, needs to supervise the executive branch, and I would apply all those principles fully.
For more congressional news, stay tuned to Congress Clips, and thanks for watching.